Mr. Duval, good morning.
Good morning.
Could you sit down for a moment, Mr. Duval, while I address Mr. Valayden? Mr. Valayden, perhaps it's the afternoon in Mauritius now, is it?
It is, and it's also very hot.
Good. Can you hear me?
Yes, I can, very clearly.
Can you see all 5 of the members of the board?
I can see only 4, the one on my right, but is on the left of her ladyship. I can't see. Now I can see.
You can see all 5 of us.
Move further across.
If at any stage you have difficulty in hearing what is being said in this courtroom in London, please put up your hand and we will pause to find out what the problem is. Is that acceptable to you?
It is acceptable. Thank you.
Thank you. Very well, Mr. Duval, present your appeal.
My lady, my lords, as the papers indicate, I am Hervé Duval of the Mauritius Bar, and I appear for the appellant. My learned friend Rama Valayden, for the respondent, join us via video link from Mauritius.
Mr. Duval, I suggest you keep your voice up to a considerable extent.
All right. The appellant is aggrieved by the decision of a court of civil appeal which quashed the order made by the trial judge in December 2014 and dismissed her plaintiff summons, which had been lodged some 10 years earlier. I propose to start with a very rough roadmap in the hope of some indication at an early stage on those issues on which the board wishes me to focus. Before that, allow me, for the record, to confirm that the appellant is not pressing on grounds 4 and 5 of the grounds of appeal. So, to the roadmap, and I propose 5 brief stops. First, a brief recap of the material facts, focusing on those found proved by the trial judge, which were not challenged by the respondent on appeal, and which were not disturbed by the Court of Civil Appeal. The complaint of the appellant in that regard is that the Court of Civil Appeal simply ignored those material facts. 2, quickly highlighting from the judgment of the Court of Civil Appeal what, in my respectful submission, illustrates the peculiar approach to the record as was found before the Court of Civil Appeal. 3, a short demonstration that the judicial mind of the Court of Civil Appeal was consumed by a finding which the trial judge never made. This will lead me to the crux of this appeal. 4, the validity and enforceability of the 2001 deed, consistently referred to as the contre-let. I will deal in the process with the contention of the respondent that I should not be allowed to make before this board an argument which was not raised earlier. With the leave of the board, finally, I will conclude by dealing with grounds 2 and 3 of the grounds of appeal together to develop my argument that the trial judge was bound by the decision of Imhoff versus Boulaki. That is, of course, the general approach adopted in the applicant's case at page 490 of the electronic bundle, and the speaking notes filed to supplement that case as from page 497 of the electronic bundle. Now, if that course is acceptable to the board, I propose to turn to the facts.
Mr. Duval, it's very helpful that you should have explained the format of your submissions in that way. Please now develop it.
Now, turning to the facts. If I can take the board to the statement of facts and issues, which is to be found as from page 477 of the electronic bundle. At page 478, we have what has been entitled the factual background, and at page 482, as from paragraph 27, we have a recap of the material findings of fact of the trial judge.
We've got the statement of facts and issues. We've read it carefully. But could you note that not all of us have the MS numbers at the bottom? So insofar as you referred to paragraph numbers, that was particularly helpful.
Thank you. Now, I would like to draw attention to 6 points about the facts. The first one is that in 1987, the decision to purchase the land was a joint decision. 2, that the purchase price of 68,000 rupees was settled by the respondent contributing 18,000 rupees and the appellant the balance of 50,000 rupees. 3, the land was purchased in the name of the appellant, in the name of the respondent, because the appellant, as a non-citizen, didn't have the right to acquire immovable property, and she had not married the respondent yet. 4, since that purchase, the appellant has lived in Mauritius, financed single-handedly the construction of 2 blocks of apartments on the land over a period of a minimum of 8 years, 1988 to 1996. 5, 1 block was built before the marriage in 1992, and the other, together with a swimming pool, after the marriage. And finally, 6, the appellant acquired the Mauritian nationality in 2004 and has continued to live in Mauritius ever since. Now, if I can go to steps 2 and take your lordship to the judgment of the Court of Civil Appeal bearing those facts in mind.
Yes, thank you.
Now, page 331, the first paragraph reads as follows. I quote, "The central issue in this appeal relates to the validity of a contre-let signed by the appellant and the respondent in 2001 to explain what they claimed to be their real intention. When the appellant had in June 1987 purchased a plot of land at Pérébert in his own name and subsequently put up 2 buildings thereon with a financial contribution from the respondent," unquote. Here, of course, before the Court of Civil Appeal, the appellant was then the respondent. And I find it peculiar that the court should refer to the contributions of the respondent in appellant now, when in fact it was agreed that the decision to buy was a joint one and that she put up 50,000 out of 68,000. Now, the second paragraph, as from line 27, if your lordship are with me.
Yes.
In June 1987, the appellant purchased a plot of land in Pérébert for the sum of 68,000. The respondent claimed that she contributed the sum of 50,000 towards the purchase price, but that the purchase price was made in the name of the appellant only inasmuch as they were not married at the time. She also claimed that the 2 bungalows subsequently built on that plot of land were so built in her denier personnel. I stop here. Claimed, my lord, at this point in time, there is a finding of fact that she did pay 50,000, that she did finance the construction. At this point in time, those facts are not disputed. They're not a claim anymore.
Did the Court of Civil Appeal go on to say that the claims were upheld?
Yes, because they don't discuss the finding of facts at all.
So my question was, did the court go on to say that your client's claims of a contribution
not in specific
were
words.
upheld?
Not specifically. There is not an express finding that these claims were upheld by the trial judge.
Yes?
Now, if I now like to turn to page 332, the next page, line 7. I quote, "The appellant is now challenging the finding of a learned trial judge on the issue of validity of a controlette on the ground that it lacks the characteristic of simultaneity," unquote. My lords, if we look, in fact, at the skeleton arguments before the trial court, and that will be at page 313 for the skeleton arguments of the then appellant, now respondent. Now,
I thought you said the skeleton argument
on behalf
at the trial court. Surely we're looking here at the skeleton argument to the Court of Appeal.
Yes, that's right. The skeleton arguments of the appellant before the Court of Civil Appeal.
Very well.
Yes, but that is at page 313.
Yes.
Now, if we turn to page 314, as from paragraph 10 to paragraph 14, which end at page 316, we see that the crux of the appeal was the issue of illegality, the issue of an illicit cause. That was the heart of the appeal. And the issue of contemporaneity is favored with only one paragraph of a mere 4 lines, which is at paragraph 15 at page 316. Now, if we now turn to the hearing before the Court of Civil Appeal, which is at page 325. And page 326, line 8, we see that Mr. Valeyden confirms what is the crux. Here it's written crust, that's obviously a mistake. The crux of the argument. I quote, page 6, paragraph 9, because the whole crust, meaning crux, of the argument of the appellant is the fact that the controlette is not valid, inasmuch as it is illicit and is done contre l'ordre public, unquote. That was the crux of the respondent case before the Court of Civil Appeal. And you will see at the next page, at page 327, how the presiding judge, the Chief Justice, prompted without much success further submissions as regard the issue which clearly was his main focus, that of meeting of minds. Now, at line 32, quote, anything any one of you would wish to say on the issue, Mr. Sauzier, no, of contemporaneity over and above whatever there is. And no further submissions were offered. So that is why I find it peculiar that the whole of the appeal, judgment, is focused on one issue, which was clearly not the focus of any other party before it. Which take me to step 3, if I may, which is the finding which consume the judicial mind of the Court of Civil Appeal. And for that, I would like to turn to page 331, still on the judgment of the Court of Civil Appeal, line 38. I quote, the learned trial judge found that the document voluntarily signed by the parties on 19 November 2001 in the office of Mr. Notary R. Hart de Keating was a valid controlette, unquote. Now, we must also, to be complete, have a look at page 333, line 25, where we can read the following, quote, "The learned judge did not address his mind to the question whether there was un lien d'ordre intellectuel between the deed of 1987 and that of 2001, unquote." And here, in those two quote, is the whole of the judgment of the Court of Civil Appeal. That is how it decided the case in favor of the respondent on that single issue. Now, both statements are factually incorrect. To demonstrate it, we must first go to the ruling of the trial judge delivered on the 9th of June 2011, as from page 87 of the electronic bundle. Start from page 87, and if I can take you to the bottom of page 88. I quote, "So it is clear from the above that although the contre-lettre in this present matter has been drafted well after l'acte ostensible, it does not render the said contre-lettre null and void, provided the plaintiff, in adducing evidence, is able to satisfy the court that there was simultanéité intellectuelle or meeting of the minds, as has been rightly submitted by plaintiff's counsel. The issue of contemporaneity has been addressed to at paragraphs 19 and 20 of the plaintiff's summons. If there's an is missing, sorry, there's nothing missing, it's me reading too much. It now remains for the plaintiff to satisfy the court on that issue, unquote. So clearly, the trial judge did address his mind on that issue, and as at June 2011, he considered that there was not enough for him to make up his mind. And if we take a leap and go to his judgment, his final judgment, which is at page 202, look as we may, we will not find any finding relating to that issue. No indication that he is satisfied or not satisfied. It is, however, submitted that the inescapable inference to be drawn from that judgment as a whole is that the trial judge found that no necessity to make a finding as regards meeting of the minds. Clearly, he decided the issue regarding contre-lettre on illegality. His finding that the purpose behind that contre-lettre was to create a trust in favor of a non-citizen was enough for him not to enforce that contre-lettre. So it is my humble submission, not only did he not make any finding that the contre-lettre was valid, but the fact that he did not enforce the contre-lettre is the best indication that we have that he came to the opinion that it was not valid. Now, and in that connection, the appellant's complaint is that the Court of Civil Appeal has not adjudicated on the facts found proved by the trial judge. Now, it is in the case of National Westminster versus Spectrum Plus Limited that this Honourable Court reminded one and all of the basic role of a court of justice. And I quote from paragraph 4. The starting point is to note some basic, indeed elementary, features of his country's judicial system. The first concerns the essential role of courts of law. In the ordinary course, the function of a court is adjudicative. Courts decide the legal consequences of past happenings. Courts make findings on disputed question of facts, identify and apply the relevant law to the facts agreed by the parties or found by the court, and award appropriate remedies.
Mr.
Unquote.
Duval,
Yes.
I'm sure you're coming to this, but did your predecessor, who I think was Maître Sauzier, say to the Court of Appeal, it really doesn't matter whether the 2001 deed is a valid contre lettre or not, because I ask you to reach a conclusion upon the facts found?
Well, I believe you will see that throughout his case, Mr. Sauzier started from the very hearing saying, we are bound by IMOF. And for him, it was not that the contre lettre was not valid. It was never his case that the contre lettre was not valid. For him, the contre lettre was proof of the past happenings. And you will see that in the exchange, at one point in time, there is an issue whether he has to put in all the receipt of the credit card of the appellant. And he says, I did not anticipate to do that because for me there's a contre lettre. The contre lettre is proof that all these payments were made. So to answer your question, my lord, I do not think he said the contre lettre does not matter. I think he said the contre lettre does matter. The contre lettre is proof of the version of the appellant that she paid everything. May I?
Thank you.
Now, the answer of the respondent, my lord, to this particular argument, in the complaint that the court did not adjudicate on the proven facts, is that, well, it was only the issue of validity which was before the Court of Civil Appeal, and therefore the Court of Civil Appeal was limited to deciding that issue. I beg to disagree. I submit that the correct proposition in view of a Section 9 of the Court of Civil Appeal is that the Court of Civil Appeal looks at the whole case. And I have with me copies of the Court of Civil Appeal Act. I do not know if your Lordship wished to have copies of them. They were not in the bundle. Obviously, I'm relying on them as a reply to the argument of the respondent. But I do not believe...
Let's wait to see what Mr. Valaiden says.
Okay.
And then you will be able to judge whether you wish to put it in, if allowed to do so.
All right, thank you.
Before you go on to that, can I just ask about the first instance judgment, which was there for the Court of Appeal? We can see with your explanation, if you prove to be right about this, that he doesn't find it a contre lettre. He finds that it is tainted by illegality. And therefore, the only thing he says, as I can see it, he quotes from Imhoff, but in a, well, leave that to one side. He doesn't say what the ownership of the property actually is. He just says it has to be sold.
Yes. In fact, I understand the trial judge as saying that the contre lettre, the content of the contre lettre, shows that as from 1987, the intention was for the respondent to hold the property in trust for the appellant. It is in that aspect that he felt bound by Imhoff, by saying, therefore, the 1987 deed was tainted. And again, for him, the 2001 deed, called contre lettre, he used that term throughout, but he never makes a finding as to whether that is a proper characterization of that document. He actually says the contents of that contre lettre reflects what has happened between the parties, and I'm satisfied that the contents indicate that the intention from the beginning was to create a trust.
And that can exist, notwithstanding the illegal purpose of the contre lettre.
I believe that is what is the illicit cause and what makes the whole of a transaction vitiated.
Yes, in that regard, we might look at the paragraph which begins on page 209 at letter 6. Starting at 7, I can only conclude that the sale effected as per the title deed. Now that's the 1987 purchase, is it,
Yes.
Mr. Duval?
Yes.
is void because its purpose was to enable the plaintiff, then a non-citizen, to acquire and hold property in Mauritius.
Yes.
So is he there making a finding that the purpose back in 1987 was for your client to hold property?
Yeah, through a prête-nom. That is what the whole
Through
case
a
of
prête-nom, which, would we translate that as nominee?
Nominee, yes. The beneficial owner being the appellant, the nominee being the respondent.
Very well.
And of course, in French law, prête-nom by itself, there's nothing sinister, except as long as the cause is not illicit. And here the cause is illicit because it meant to circumvent a provision of the Mauritian law.
Yes, well, let's proceed, please.
We also see that, do we, at page 208, lines 32 onwards. There can be no doubt that at the time the land was purchased, plaintiff was a non-citizen, and given the contents of the letter, the acquisition of the plot of land is tainted. Yeah. Although he then goes on to say, since the purpose behind the contra letter was for the defendant to hold the property in trust. Yeah. I think I've understood his decision to be all about the illegality of the original purchase.
And the irony of it is that this is precisely what the respondent argued before the Court of Civil Appeal. If I now can take you to page 512.
512? 512?
No, I'm sorry. No, my mistake. That is at page...
What's the document?
If your Lordship would bear with me. The appellant skeleton argument before the Court of Civil Appeal would start at page 113. And if we turn to page 3, I'm sorry, did I say 313?
313. So this was the husband's skeleton argument.
Yes. And if we turn to page 315, we see a reference to French doctrine. As from line 24, we read, dans certains cas, la loi frappe de nullité non seulement la contre-lettre, mais aussi l'acte ostensible. C'est alors l'ensemble de l'opération qui est remis en cause. My Lord, unfortunately, we haven't translated the French doctrine. At my last visit before this Honourable Court, I was reminded that there's nothing I could help the courts with French. But this basically only says where the law will invalidate the whole transaction if the contre-let itself is illicit. And that is exactly what the trial judge did. He did not make a finding that the contre-let was valid. He made a finding that the cause was illicit and that invalidated the whole thing. And that is why I come back to Imhoff, as he did. That was decided by the Court of Civil Appeal, and that decision was binding upon him. Now, if I may now turn to the validity and enforceability of a 2001 deed. Now, again, if we go back to the finding of the trial judge,
Yes.
which is a ruling at page 91. And we are back to that, as your Lordship rightly pointed out, the operative part of his ruling, which is basically said that if the contre-let is valid by virtue and passes the test of Article 1108 of the Code Civil Mauritian, then it must be enforced intra partes. Now, however, you will note that the purpose of putting the controlette before the the trial court, was not to have it enforced in the sense that this controlette contained an undertaking that the respondent will, on demand, transfer the land to anybody of the appellant's choice and remit to her the proceeds of that transfer. What was said, or if we look at the pleadings, the way the case was presented was appellant paid for everything. This was admitted in 2001 by the respondent. Appellant is therefore the owner. She is entitled to a declaration that she is the owner, and she's entitled to an order directing the respondent to transfer the property to her. That was the case of the appellant. And throughout, we can see, my lords, that the controlette was used as proof. And you have the very important testimony of the notary who drafted the controlette. I stress here that the controlette is not a notarial deed, but the evidence was that it was drafted by a notary, Mr. Notary R. Hard-de-Kitting, who deponed before the court, the trial court, and his testimony is to be found at page 168. Now, if we look at line 23, the question reads as follows. Dites à la Cour ce que contient cette controlette. The answer, c'était pour établir l'origine des deniers. I stop here. Obviously, that is the wrong word. That is l'origine des deniers. And it is clear when we look at the translation, deniers was translated as information, when in fact it is monies. And that is clear when we look at the controlette itself. When it is translated, it is properly translated. So,
what is the French word that should...
Denier. Denier. D-E-N-E-E-R. If I take your lordship to the actual document at page 211, at page 211, my lords.
Yes.
Line 20. Payer de ses deniers personnels.
Oh, denier. Yeah. Right. Thank you. Yes.
C'était pour établir l'origine des deniers pour l'acquisition d'un immeuble dans le Nord. So that is the notary, the person who drafted the document, who gives first-hand evidence to the court as to the purpose of the document. And he repeated that under cross-examination at page 169. Question at line 11. Non, quand vous avez rédigé ce document, vous saviez que la dame Emma Suppo ne pouvait pas devenir l'acquéreur d'un terrain au moment où ce terrain était acquis par son époux. Answer. Donc, je n'ai pas moi qui ai rédigé le contrat d'acquisition. Obviously, my lord, the person writing the transcript had problem understanding what Mr. Hard-de-Kitting was saying. Donc, ce n'est pas moi qui ai rédigé le contrat d'acquisition. J'ai simplement établi à leur requête l'origine des données, again, it means denier. C'est tout. That's all. So all he did, according to him, was to set on record the source of the funds for the acquisition. So that was the purpose of the controlette from the very beginning.
Well, it did contain an undertaking.
It did.
To transfer the property
yes.
at your client's order.
Yes.
So in a sense, I mean, whatever the gentleman one often says you should never ask a draftsman what a document that he's drafted means.
In fact, I believe...
Whatever he said, it clearly contained that undertaking. And that undertaking was sued on in your original plaint.
Yes, but I think in fact, and that is why the trial judge found that there was a transfer. That undertaking made it, because if it was only the source of the acquisition, that could have been a recognition of debt, reconnaissance de dette. That undertaking took it to something else. And I guess the notary was reluctant, as one would be, to admit that he was drafting something which was not in line with our law. But obviously, my point is that we have, before the trial judge, first-hand evidence of what the intention of the parties were in 1987. And we have first-hand evidence of what the intention of the parties were when we went to the notary to draft this document, the controlette. So when the Court of Civil Appeal says this is not a valid controlette, I respectfully do not disagree. What I cannot understand, but this is the end of the matter for the Court of Civil Appeal.
Why is it not a valid contre-lettre?
Because there is no evidence that when the 1987 deed was being entered into, that the parties intended to enter into a subsequent secret agreement which would nullify the acte ostensible. In fact, these are the authorities cited by the Court of Civil Appeal, and I believe there is no dispute about the law, but I'm afraid the Court of Civil Appeal did not make a distinction between an acte secret, a secret deed, and a pacte secret, a secret agreement. Clearly, in 1987, we have it from the appellant herself. She was madly in love. She couldn't think of anything bad happening to her, so she did not have a foresight of taking the precaution of saying to her husband, I am paying for this now, but I want you, at some point in time, to enter into a document to pay homage to the truth. What she says is that when she built the second house, because the money came from the father of the children, that was a patrimoine of her children, she wanted to make sure that this patrimoine will not be lost. And that is when she insisted on the controlette, and that it is the respondent who wanted to go to a notary, because he said, I'll sign something, but something prepared by a legal person. And that's how they ended up before the notary. So clearly, the acte secret was not in the mind of the parties in 1987. And that is why I think the Court of Civil Appeal is right. This is not a valid controlette. My problem, however, my lords, is that they stop there. And in my humble submission, they should not have stopped there, because there were facts found proved. She had paid for everything. He had voluntarily entered into that agreement. It was maybe not a controlette, but it was something.
So is that the pacte secret?
The pacte secret. For me, the pacte secret
is in 2001.
No, I'm sorry, if I may. For me, 2001 only confirms the existence of the pacte secret in 1987. And we have it at page 136, if I'm not wrong, if your ladyship will bear with me. Yes, my lady, if you look at page 136, under cross-examination at line 16, under cross-examination, the appellant recites a conversation she had with her husband in 1987. Et M. Jhundoo m'avait fait part de cela et m'avait dit qu'il y avait beaucoup de personnes qui font le prête-nom, et quand la personne après de vendre son terrain, l'autre personne le garde en disant « Non, c'est mon nom ». Et je lui ai dit la phrase « Est-ce que toi, tu ferais une chose pareille ?» Il m'a dit « Moi, non, jamais. » Et je suis en procès aujourd'hui pour ça. Unquote. So, clearly, the Court of Civil Appeal, when they say there is no indication that the 1987 Act is tainted, clearly they are overlooking that evidence.
But what I'm trying to just get sorted out in my own mind is why, if there was a pacte secret in 1987, there wasn't sufficient meeting of minds for it to be a contre-lettre when it was later reflecting it.
I believe there is a contre-lettre because the authority in France says that a contre-lettre needs not be in writing.
Yeah.
That is why I'm making a distinction between the acte secret and the pacte secret. But contre-lettre need not necessarily be in writing. And that is my humble view where the Court of Civil Appeal went wrong. It cited all the cases concerned with acte secret and the need for the parties to have anticipated the acte secret at the time they enter into the acte ostensible. That I have no problem. But I've also cited some motion cases, one judge bench, where the principle is applied. The principle that an agreement of prête-nom need not be in writing and will be enforced in the court subject to proper proof being obtained. That is why at one point in time I will go on about my main argument in front of you, my lords, is that the 2001 deed may not be une contre-lettre, but it is proof that there is a contre-lettre. And even if by itself it is not valid proof, it is at the very least a commencement de preuve par écrit, opening the door to oral evidence, that of the appellant, which the trial judge accepted in toto.
Do you accept that you have to show a commencement de preuve de l'écrit?
For me, the 2001 deed is by itself an écrit.
My
which
question
is
in law,
Yes.
in the Mauritian law, do you have to show
Yes.
a commencement de preuve écrit, or whatever it's called?
If it is more than 5,000 rupees, you need a writing to prove an obligation of more than 5,000 rupees. If you do not have a writing, there are many ways to open the door to oral evidence, and one of them is commencement de preuve par écrit.
And that is Dallos,
Yes.
note 70, behind tab 8.
Does someone have an electronic page for that?
Your Lordship is faster than me. Allow me just enough time to catch up.
Yeah.
A different thing.
Your Lordship was referring to Dalloz.
Can you help Lord Briggs with an MS number for
We have
tab 8, the cover page, and more particularly the notes on the reverse?
the page is 636 of the
66.
bundle.
66?
636.
636, thank you.
Let's pause to see whether Lord Briggs agrees.
That's certainly the front page.
Good, well then you need the next page.
Yeah, it's at note 68 is what?
I was referring to 70, but can we go through 68
Yes.
and 70, please,
Yeah, I
Mr.
will.
Duval?
Yes.
You do it for us.
Is Lord Briggs with us?
Yes?
Yes. So from note 68, I quote, En dépit de son nom, la contre-lettre ne doit point être nécessairement faite par écrit. En l'absence d'un texte qui exige l'écriture, on doit admettre la validité d'une contre-lettre consentie verbalement. Mais la preuve d'une contre-lettre ne peut être fournie que suivant les règles du droit commun. Ainsi, en l'absence d'un commencement de preuve par écrit, la preuve testimoniale ne sera être admise au-dessus de 150 francs. That's a limit in France, or it was. That's a long time
You've
ago.
got a different limit, obviously.
Yeah, we
for
have
Mauritius,
5,000.
But note 70 applies,
Yes,
and you do need a commencement.
de preuve par écrit.
You
If
do.
your lordship feels that the document itself, being an invalid contre-lettre, cannot constitute proof.
Well, you've conceded that. No, you conceded that it's not a valid
Valid contre
contre
lettre.
Your submission to us, I think, was that it is proof
Yes,
of a side transaction,
exactly.
known in French as a contre lettre, misleadingly, because it can be verbal rather than written.
Indeed.
Yeah.
I had, I'm afraid, assumed that contre lettre meant something in writing, but I understand your submission that it
I
doesn't.
believe that is a very fair assumption, one clearly that the Court of Civil Appeal made.
But was the objection on which the trial judge ruled in his interim ruling to the validity or enforceability of the 2001 deed, or to its admissibility as evidence in the proceedings?
Yes.
Which?
It was admissibility.
Right.
Because he said the mere illegality or the mere fact that she didn't have the right to purchase doesn't stop her from coming to court and say it was my intention to purchase.
Now, that's quite clear from the bottom of page 87 of the judge's preliminary ruling. Counsel for the defendant, I'm going to call him the husband because it's easier to remember that way. Counsel for the husband submitted that the contre lettre was made in effect for an illegal purpose and is therefore inadmissible. That is the contention that the judge was dealing with, as I understand, in this preliminary ruling.
Yes. So he never made a finding on the validity of the document as a contre lettre. My lords,
So, looking at your roadmap, Mr. Duval,
Yes.
we've been on number 4.
yes.
Have you completed 4? Do we proceed to 5, or is there more to be said under 4?
I believe that in answering your question, I have covered everything I wanted to cover, except maybe to draw attention that all the cases, the motion cases in the list of authorities are here only for illustration purposes. How the issue, for example, in the case of Garni, at page 594, the facts are quite similar.
I think you did. I'm not sure you've done ground 5, which was in particular in relation to Imhoff.
Yes.
You want us to look at Imhoff?
Okay?
Well, just before you come to that,
Yes.
Monsieur Duval, you flagged, you indicated in advance when you were listing your 5 points that you might need to deal under number 4 with what you understood Monsieur Valadin's submission might be, to the effect that you can't be heard to say that there was a commencement de preuve par écrit because it was a new point that hadn't been taken before, or for some other reason.
Yeah.
And do you want to deal with that now, or
Yes.
do you want to wait and see what
No,
he says?
If your lordships, I believe, have a straight and complete answer to that. The first thing is that even if it was a new ground of appeal, which I submit it is not, in the recent decision of this court in De La Haye versus Air Mauritius, your lordships clearly explained the reluctance to accept before this court at this stage a new ground of appeal, and when, exceptionally, it will do so. And you will see that when I dealt with that issue with my appellant's case, I actually dealt with it sort of ticking along all the requirements of De La Haye. That is at page 495 of the electronic bundle, paragraphs 24 to 26 of the appellant's case, where I deal with why, even if it was a new ground of appeal, it ought to be allowed. But my complete and hopefully clear answer to Mr. Valayden's point is that it is not a new point. It is simply on the issue of validity. Had the Court of Civil Appeal asked itself the right questions, meaning this is not a contre lettre, is it anything else? It would have been bound to find that it is at the very least commencement de preuve par écrit. Because before the trial court, Mr. Maxime Seusier, senior counsel, kept on repeating that contre-let is proof. I did not expect to need anything else than the contre-let. And in fact, there is a page, if I may take you that, where he actually disclosed his tactic, that it is at page 134. There's an exchange between the bench and Mr. Seusier, which is most revealing. Now, 134, top of the page. If your Lordship are with me. So it's an exchange between Mr. Seusier and the bench. My Lord, quote, she says all the documents are with her. Mr. Seusier, yes, I can understand where your Lordship is going, where my friend is going. I have got all the carte bleue. It would mean 2,000 documents. Quote, but you have produced the carte bleue? Mr. Seusier, no, my Lord, because there is a letter, which is how can my friend go along that? If I was wrong, I would have been doomed. This is what I said on the last occasion. I must say from now on, he's interrupted, the letter you mean? Mr. Seusier, of course, quote, the contre-let. Mr. Seusier, the contre-let. Quote, yes. So how is the defendant going to speak? I will object from the word go. Clearly, Mr. Seusier was referring to the fact that the respondent, having admitted in the contre-let the source of the funds, would be debarred from giving evidence to the contrary. The sad thing for the appellant is that she changed counsel. So when the husband was examined, there was no objection to him going contre the contre-let. But that was clearly the tactic of Mr. Seusier. So, that is why, my Lord, I say this is not a novel point. This is about the validity of the 2001 deed. It's simply something which a Court of Civil Appeal did not address its mind on. I believe, unless you want me to...
Did you want us to look at the Imhoff case?
Yes, yes. Imhoff case is at page 615 of the electronic bundle. So
Yes.
the facts of Imhoff are this. Brothers and sisters decide to acquire land in Mauritius, except that the brother, to be able to practice medicine in Germany, had renounced to his Mauritian citizenship. Now, at the time the sister enters into the acte ostensible, the title deed, there is, on the same day, another secret deed, l'acte secret, in which she recognizes the fact that she holds 50% interest in the property in trust for her brother. Now, subsequently, the brother resumes his nationality, and as things happen sometimes, brother and sister fall out and they end up in court. The trial judge enforces the contre-let and directs that the sister should appear before a notary to acknowledge the interests of her brother. The sister goes on appeal, and the then Chief Justice, Mr. Sikuen, and Mr. Matadin, now our Chief Justice, who decides this case, find that, well, she is cutting her nose off, because by arguing that this contre-let is illegal, because at the time her brother was a non-citizen, the only alternative is to send it to the curator and have the curator proceed by way of judicial sale under the Immovable Property Act, Sale of Immovable Property Act. Now, I would like to just point out that the principle of IMOF is concerned with the intention of the parties at the time of, from the very beginning is a phrase used, so at the time of the apparent transaction. And in my humble submission, even in IMOF, the contre-let was used as proof. Even in IMOF, the contre-let was not enforced.
But I think you told us that in this case there was a contemporaneous acte secret.
In IMOF,
Whereas
yes.
in our case, you are submitting that there is a contemporaneous pacte secret.
Exactly.
So that's not quite on all fours.
But in my humble view, what the operative part of IMOF, if I may, if we turn to page 625, 625, the one before last paragraph, which in my humble submission is the pronouncement. We must, however, hold that since the property was purchased as a whole by appellant number 1 in her name only, the purchase of the whole land was tainted since the underlying transaction was that appellant number 1 would in fact be holding a house share if the property in trust for a non-citizen, which is prohibited by law. The ratio of IMOF does not refer to acte secret. It refers to an underlying transaction, and it's not limited in my humble submission to where there is a acte secret entered at the same time. It is an underlying transaction which is the crux of the matter, which makes the whole thing tainted. And in my humble submission, there is evidence in our case of the pacte secret, of what was the underlying transaction, namely that he was to be holding the land for her. And that is why, in my humble submission, this is binding. My Lord, we have to remember is that the trial judge did not give a judgment in favor of the appellant. And I find myself in a particular situation when I say restore the order of a trial judge, which is not in my favor. Because it's, in a way, none of the prayers in the plaint with summons were entertained. But that is the legal consequences of...
It was economically in your client's favour, wasn't it? Because as I understand the Act, when the sale takes place, the net proceeds are to be distributed to the foreigner or other person entitled.
Indeed.
Which, as I understand it, would be to your client and Mr. Jhundoo in the ratio, whatever it is, 50/18,000 rupees contributed to the original purchase.
And that is why in my submission I submitted humbly, because I know there is no law, there is no case law for that, but that in equity.
Well, that would be, Lord Briggs' figures would refer to the proceeds of sale of the land.
Yes. And
I think the buildings are a different situation.
And I think that he rightly said 18 out of 68. That was his contribution to the purchase of a land.
Well, that would all be for the registrar.
Yes.
If you were to succeed
Yes.
in this appeal.
Yes.
But I don't understand your saying that you didn't succeed before the trial judge.
Well, the trial...
Why do you say that?
Because the prayer was that she be declared the true owner of the property. Yeah. That was a prayer before the trial judge. And that prayer was not entertained.
Yes. So you didn't get what you originally asked for, but of course, if you were to succeed now, by the look of it at least, you would certainly get some valuable result.
Yes, I mean, at least, because that is where I wanted to conclude at the end of my submission, is that allowing the Court of Civil, the judgment of the Court of Civil Appeal to stand creates a great injustice. Because if there was a problem, both parties were equally guilty of something, trying to circumvent the law. Now, the Act provides that a transaction which contravenes its provision will be cancelled and the foreigner gets back his money. That's the system of the Act. With the Court of Civil Appeal, we know that someone who has only paid 18,000 out of 68, who has not paid a cent out for the two buildings constructed thereon, someone who has tried to lie before the trial court, who was found to have given scanty evidence as best, he ends up with everything. That surely cannot be what the laws of Mauritius meant to happen. My lords, with your question and your help, I believe I have addressed everything I wanted to address. Unless there's something else.
Let me look at my 4 colleagues to see whether they have any further questions for you. It looks as if they don't. So at the moment, all I say, Mr. Duval, is thank you for your assistance so far. Please sit down. We're going to rise for Mr. Valaiden. We're going to rise for 2 or 3 minutes, if that's acceptable to you.
It is.
Thank you. Now, Mr. Valaiden.
Yes, my lord.
Thank you. That's very good manners of you to stand up. But, Mr. Valaiden, we think that the camera will better catch you if you're sitting down. So would you please make your submissions sitting down?
Yes, I will. Okay.
Thank you. We will try to speak very slowly and clearly. But if we fail, you must tell us.
Yes, okay, thank you. My lords, I will start with the issue of contre-left. My friend has stated that it is not a contre-left, and he agrees that the finding of the Court of Civil Appeal of Mauritius is right on the issue of contre-left. And if the Court of Appeal had to decide only on one issue, whether the contre-left, what is in translation the counter deed, is valid or not. And this is the first hurdle that the Supreme Court, that the Court of Appeal had to establish. And in fact, they stated, the judges of the Supreme Court stated that it is not a valid contre-left for the reasons they gave at page 333 of the brief. At page 333,
yes?
Yes, at page 333, paragraph at line 25, starting with the learned judge did not address his mind to the question of whether there was a lien intellectual between the deed of 1987 and that of 2001. They go further. After considering the evidence on record, I emphasize, we are unable to say that the purchase by the appellant in 1987 was sous la dépendance directe et exclusive of the document signed in 2001, which, according to the respondent, indicated the true intention of the parties, as we are unable to infer from the evidence on record un lien intellectuel existant dans l'esprit partie de l'origine. My lord, if the judges had found that it was a valid contract, then they would have gone further if need be. But if there is no contract, it means that the 1987 deal is an untainted deal, and the contract of 2001 has nothing with what happened in 1987. Therefore, as
Mr.
such,
Mr. Valeden,
yeah.
we can just about hear and decipher what you say, but if you could speak even more clearly and slowly,
Yes.
it would be even more easy for us to do so. I think your last proposition, which sounded to me very important and I wanted to note, was if there is no contre-let, then, and can you repeat the next bit, please?
Yes, if there is no contract, then the deed of 1987, the deed is valid, and it is not tainted in any way whatsoever, and the judges found that is not tainted because it is done according to the law. That's
Because
the
what?
only issue. It is done according to the law.
According to law.
It is stated also, let me quote what was stated on line, page 333 of a brief at line 37, starting with 37. The deed of 1987 cannot accordingly be impugned, the more so as it had been duly registered and transcribed in accordance with law and does not appear to be tainted in any manner whatsoever. My friend has stated that on the issue of contre-let, that the findings of the Supreme Court, of the judges of the Supreme Court, is unassailable. But now, my friend is trying to bring another issue, that is the Pacte Secret. On the issue of Pacte Secret, we will be developing a new ground of appeal. And the new ground of appeal will be putting in the bin the issue of contre-let and by stating that the contre-let can be used as a commencement de preuve par écrit. But when we look, my lord, let me pause here, when we look at the whole case from day one, that is from the day one in 2006, 15 November, when the plaintiff with summons was entered by the appellant, the contre-let was the kingpin of the case. Let's go to bear with my lord, let's go to yes, at page 5, my lord, page 5, start with the plaintiff with summons. And we'll see that again, it is written, it has been prepared by Tony, and as from paragraph 19 of a plaintiff with summons, which can be found at page 7, plaintiffs averse that on or about the 19th November 2001, the defendant signed a contre-let. Paragraph 20, next page, my lords, again, it refers to the contre-let. Paragraph 21, it refers again to the contre-let. And the only documents which were submitted at page 9 is contre-let. And when we look at the contre-let, which is prepared by the notary, at page 211, my lord, we will see again that document P1, 211.
Yes, we have that.
Yes, and the title itself is contre-let. Now, when we go for the demand of particulars by the plaintiff, by the respondent. It is, again, it's around the controlect. In the plea, again, it's about controlect, and the reply also to the plea at page 30, paragraph 20. Paragraph 20 will enlighten us on two issues. Let me read it with your permission, my lord. Paragraph 11,
which page are we?
Page 30, my lord.
30? Thank you.
30. Paragraph 11.
11.
Yes?
Line 20, I read. The plaintiff strenuously denies the averments contained at paragraph 14 of the plea, maintains the facts, matters and things set out at paragraph 19 and 20 of the plea, and avers that the said controlect was the defendant's idea in the very first place. The plaintiff avers that she wanted the defendant to sign a reconnaissance de debt by way of a private deed, but the defendant himself insisted on having the reconnaissance de debt recorded before a notary public. My lord, therefore, the whole case, if we look at it, the whole case from the examination in chief of the lady, the appellant, and the cross-examination, even the cross-examination of a notary by my learned friend, Senior Guyane SC, was around the controlect. The examination and cross-examination of the respondent was also around the controlect. But to say that it is now not a controlect, but it's a commencement de preuve, and there is also what we call a pacte secret. The pacte secret, the line is given at page 384. It is there to be a pacte secret, which will be used later on. At page 384, there is an important, this is why the judges of the Supreme Court, in my humble opinion, were right. Line 20, page 384, Mr. Anil Gayan SC. But if that was the case, madam, when in 1987 the land was purchased, why did you not go to your friend the notary or the Keating to draw the controlect? But there was no such wrong thoughts, my lord. At that time, it was a passionate love that I was living. I was not worrying of what would be happening later. Therefore, at no moment in time, in that answer, and also when we look at the controlect, whatever name, if my friend wants to label it, reference could have been made to the fact that they agreed already when they were going to buy the property to whom it belongs, but we have none of that, not iota of evidence on that issue. And therefore today, by saying that it is a commencement de preuve par écrit, is causing an injustice to to respondent. Injustice in what ways? A whole demand of particulars could have been different.
I'm sorry, I didn't hear what A was. Repeat it.
The whole demand for particulars would have been different. Demand of particulars.
Demand of particulars.
Yes, my lord.
Could you do the whole sentence?
Questions and answers on the plate.
Mr. Valedin, I'm sure it's my fault. I've not fully understood point A.
Point A is that it is causing an injustice by having now a commencement de preuve par écrit and pacte secret, because if such was the case, it should have been inside the plaint with summons on the very first day. But it was not at all to be seen that it is a pacte secret or it is a commencement de preuve for écrit.
So it's
My lord,
it's an injustice because it's a new point, a fresh point.
yes, this is the point. Totally new point. Because look at the demand of particulars, my lord, which can be found at page 12, 13, and 14 of the brief. And then the answers will be given at page 16, 17, and 18. Page 16,
Yes.
under line 30, under paragraph 8 of the plaintiff summons, defendant moves for communication of any document to the effect that the plaintiff allegedly provided about 50,000. Please refer to the contre-lettre annexed to the plaintiff's plaintiff summons. Again, question next page, 17, contre-lettre. Question 11, answer, contre-lettre. Question 14, page 17, still at page 17. Please refer to contre-lettre. Question 15, refer to contre-lettre. Again, my lord, this is a central issue. Therefore,
Mr. Valeden, can I ask a question here?
Yeah.
I wonder whether there has been some confusion as a result of the simple fact that the notary headed the document contre lettre. We know that. The argument I think that you've got to meet is that one way or another, the wife, as I will call her, was relying upon a 2001 document described at the top as a contre lettre. Now, in Mauritius, you don't have to prove law, you have to prove the facts on which you rely. You'll correct me if I'm wrong. And so, is it all that big a jump for the wife to say, yes, I've been relying on the 2001 document from the word go? And the law, which in my submission applies to it, is the law about le commencement du preuve de l'écrit.
Yes, but when we look at the document or any evidence at the beginning, there is no such thing. It could have been in that document drafted by the notary. It could have been there saying it at the beginning itself in 1987, as you said, from the word go, there was the undertaking of that pacte secret that there was going to be transferred under my name. But none of that at all. Thus depriving, my lord, if we go along the line, is that the judges at the level of a trial would have had to decide whether that document was going to be a commencement de preuve par écrit. A judge in his wisdom would have had to decide on whether it is a commencement de preuve par écrit or not. And then, again, could have given permission to plaintiff in the court below to question, not under oath, the defendant on fait et article, but is to try to get certain evidence from him.
Mr. Valeden.
Yes, sorry.
Why wouldn't the 2001 document constitute a commencement du preuve de l'écrit?
The 2001 could have constituted a commencement de preuve par écrit, but what my point is that it is by now including it as a commencement de preuve par écrit, it is causing prejudice to a respondent in view of the fact that he did not at all respond to that because of a failure of appellant.
Well,
The injustice there.
may I ask?
The witness, yes, sorry.
May I ask a question? As I read the questions in the and answers in the particulars to which you've just drawn our attention,
Yes.
you're asking, or your side is asking, well, is there any document that proves what you say about who paid for this property and who did the building of the property, who paid for the building of the bungalows? And the answer comes back, yes, look at the contre-lettre, which looks to me, possibly from my untrained English perspective, to be the claimant saying, we rely on that document not as a separate transaction, but as proof of what we say happened in 1987.
Yes, but wrongly so. Wrongly in the sense that they referred to it and misled everybody to go along the line of the conditions that a contre-lettre should have in order to be valid. If not, let me go further. If not, for example, in this case, the respondent stated that he built the 2 bungalows with the help of his brother-in-law. For example, the brother-in-law would have been called as a witness. But as it is on the issue only of contre-lettre, winning on the contre-lettre would have been enough. That's why I believe it is an injustice to raise the point of commencement de preuve par écrit at this stage, which was not done even through a counter appeal when we appealed against the judgment of the Supreme Court. There was also the, I will say, there was the avenue of the counter appeal, which was not contemplated by the appellant.
Monsieur Valadin.
Yes, sir. Yes, my lord.
Did I hear you say that if the argument had been put on the basis of a commencement de preuve par l'écrit, you would have called some other evidence?
Yes, my lord. For example, yeah.
Who or what?
Yes, for example, the brother-in-law who helped the respondent to build the place, and his name is mentioned in during the proceedings as Mr. Momi. This is one of the persons that could have been called.
To say,
sisters,
called to say what?
To say that the building was built by respondent himself with the help of the brother-in-law, but he put himself. That's why it costs less money, and there is nothing to do with appellant putting money in. And also the issue, that was a big issue, it was not in the plea, the issue of the car. Money was sent and a car was bought, but money, that evidence also could have been brought to give a lie to appellant that the money that was sent from France was money, in fact, that was sent to buy a car, and which car is being used by the appellant according to the proceedings.
I follow that, but surely the whole argument in front of the judge was about who paid for what, wasn't it?
Yes, but there was the issue, I will say the first condition was about the contre-lettre. First one.
Right.
And then the proof. My friend has been stating that there is ample proof about the 50,000 rupees what was paid by appellant for the buying of the land in 1987. The question was, there is no evidence, only mere words of appellant to that effect. Whereas respondent stated that he bought it with the help of his father. And moreover, no proof at all for the construction of the first building. Mr. Gayan has seen the court, my friend Gayan has seen the court bill, did ask question, there was nothing at all, nothing at all. 2,000 documents about Code Bleu. The total was 200,000 to 300,000 rupees, which is well below half the amount of what was stated to be spent by the lady. And even my lord.
Mr. Valadin, you're speaking slightly too quickly for us. Will you speak a little bit more slowly? And if possible, even a little bit more clearly?
Yes. Okay.
Thank you.
What I'm saying,
thank you.
I'm saying, yes, thank you. Yes, even for the buying of the land, there is different answers given by the appellant. The appellant stated at one moment, let me bring your lordship. page 390, my lord.
390.
Yes.
Thank you.
The question is from line 24, bottom.
Which line?
21 to 23. We can start with a quote. Do you have an idea?
Yes.
Yes, it is line 22. Do you have an idea of how much his contribution is for the purchase of a land? Mrs. Emma or Suppo, yes, for the purchase of a land, I think it was about 20 or 25,000. I no longer remember. Court, about 20 to 25,000 rupees. Yes, now another figure is brought forward. Yes, approximately 18 or 20,000 rupees. Then further down, page 391, to show the contradictions of different figures put forward. Line 20 at page 391. At page 391, now I remember something. At the time of acquisition, Mr. Jhundoo did not have money, and I had to bring money, which Mr. Jhundoo made me exchange at his father's place. This was his father who was present. Unfortunately, he's dead. And I exchanged the franc for 65,000, and those 65,000 I invested for the purchase of the land. Now, this is exactly the truth. So within 10 questions, we have 3 different figures.
But Mr. Valeden,
yes,
when we were trial judges, we often received confused evidence from witnesses, and we had to do our best to discern the truth. And Mr. Justice Ango did just that. And he found, did he not, quite clearly that the wife had contributed 50,000 to the purchase costing 68,000 of the land. So, having listened to all this, including a certain amount of confusion, he sorted it out as best he could. And you're not asking us here in London to revisit that, are you?
No, my lord. I am only stating that because I'm basing myself on the issue that if it is a commencement de preuve par écrit, therefore it will do justice to respondent, because respondent could have called other witnesses to prove his case, or at least to put a good defense.
Very well.
He has been, yes, this is the point that I'm going to say.
Thank you.
Yes, my lord. Now, on the issue, again, on the issue of contre-let, my lord, there is also that there is another avenue open to my learned friend or to appellant. The other avenue is, again, because he's not today restricted by the time 30 years limitation, because there has been an appeal. It could have gone again to another case before the Supreme Court through plaintiff summons, which means that he could then have thrashed whatever money he wanted to have from, she would have liked to have from respondent, if any. My lord, let me come to the point of IMOF, my lord. Let me go to, my friend tried to distinguish IMOF, my lord, but
Not sure.
yes. One second, my lord. Yes. Let me go to page 333, my lord.
Yes.
We wish to point out that the facts in the present case are different from those in the case of IMOF and Anor and Bulaki. In the case where there was clear evidence that the parties at the very beginning intended that the land would be purchased in joint ownership. It was the common intention of the parties that the whole property would be purchased in the name of the sister Imoff on the understanding that half of it would be held in trust for the brother Boulaki.
Now, thank you, Mr. Valedin. Thank you very much for drawing our attention to that, because I think that Mr. Duval says that actually there was a clear finding by Mr. Justice Ango that from the very beginning your client would hold the property in trust for his client. And insofar as the Court of Appeal thought otherwise, they had forgotten, in particular, the concluding paragraphs of the trial judge's judgment. And we'd like your help on that, please.
Yes. Let's go to page 64 of the judgment of Imoff.
Page
624.
Imhoff, right.
In Imoff, the first paragraph, it appears to us, I'm reading from the first paragraph, page 624, it appears to us that the purchase of the whole property on 22nd July 1985 in the name of appellant number 1 amounts to a simulation, and that the real transaction is reflected in document L, the stamped paper equally dated 22nd July 1985, which is a contre-let. There, my lord, there is clearly a contre-let dated, and there was a contre-let which was made on the very day, that is 22nd of July 1985, when there was the purchase of the property. So this is essential in the case, whereas here, but meeting of the minds seem not to be present.
Now, Mr. Valedin, thank you for that. You will not have forgotten that Mr. Duval interprets this case differently and says that the ratio of it is to be found in the paragraph towards the bottom of 625. And we'd like your submissions on why he's wrong about that.
625, yes, my lord.
We must, however, hold.
Yes. My lord, there, it is because, not because of a contre-let, it is because the contre-let is trying to circumvent paragraph 3, section 3 and 5 of non-citizens restrictions of property act. That's the only reason. The contre-let can stand on its own, but because there is another stringent provision under section 3 and 5 of the non-citizen property restriction act, therefore makes it become then tainted. And the law provides that if something has been done against section 3 and section 5, the land has to be seized by the curator and then sold by the registrar.
So you're taking the illegality point.
Yeah, illegality point.
But Mr. Duval, again, bouncing off you, the submissions we've just heard, Mr. Duval says it's the whole arrangement that was illegal, and that's why it's got to go to the curator, not just the contre-let, if such it was.
No, why no? I'm saying no. It is because there are the conditions that are with the contre-let don't hold at all in the case of in the present matter. In the present matter, it is a case of 1987. There is no simultaneity or meeting of the mind, no simultaneity meeting of the minds, no, I will say the issues were not of the same day, 14 years later. These are the issues concerning the present matter. Therefore, it can't be the same as IMOF.
Well, Mr. Valadin, may I ask, because this is exactly what the Court of Appeal said on page 333, isn't it?
Yes. Yes.
Line 32.
Yes. In the circumstance.
In fact, you can start at line 30, I think.
Yes.
We are unable to infer from the evidence on record un lien intellectuel existant dans l'esprit des parties dès l'origine, from the beginning. Yes?
Yes. Yes.
In the circumstances, we hold there was no simultaneity intellectuelle or meeting of the minds at the time of the conclusion of the deed of purchase in 1987. Now, I quite understand that if that was so, then the deed would be unaffected, or on your argument, the deed would be unaffected and would have to stand. The original sale deed would stand, and the husband, your client, would be the sole owner of the land. But
that's my point.
Well, that's it in a nutshell, isn't it? Yeah.
Thank you.
Go back to 209.
Yes, my lord.
The judge is coming to the end of a judgment in which he deals with who put up the money, isn't he?
Yes.
And what and having found that he accepted the evidence of the wife and rejected the evidence of the husband, his conclusion at the top of 209 is, isn't it? Look at line 7. After the reference to Imhoff, I can only conclude that the sale effected as per the title deed is void, and then this, because its purpose was to enable the plaintiff, who was a non-citizen, to acquire and hold property in Mauritius. Now, what I don't at the moment quite follow is why that isn't a finding of a meeting of the minds as at 1987.
My lord, it is because, as the judges in Mauritius stated at page 333, that after, at line 27, at page 333,
yeah.
After considering the evidence on record, we are unable to say that the purchase by the appellant in 1987 was sous la dépendance directe et exclusive.
That I understand, but it's a different point. What I'm after is why the judge's finding at 209 is anything other than a finding of a meeting of the minds in 1987.
He says it twice, just before you answer, because he says pretty well the same thing at the bottom of the previous page, starting at about line 36.
Yes.
No doubt that at the time the land was purchased, the plaintiff was a non-citizen, and given the contents of the letter, the acquisition of the plot of land is tainted, since the purpose behind that letter was for the defendant to hold property in trust. I think I read him as meaning the purpose revealed by the letter.
Right.
If we accept that the letter, that the contre-let of 2001, the whole thing is correct in it.
Yeah, well, do you agree that the judge, I mean, you may not, but I want to know, do you agree that the judge found, as a fact, that there was a meeting of the minds in 1987 under which the wife was to have an interest in the land, because she'd put up the money. Now, do you agree with that or not?
No, I don't agree with that.
But that's what that is what he found, isn't
No,
it?
what he found, yes, but I don't agree with that proposal. Yeah.
If he found that, why are we not bound, in effect, by his finding of the facts?
Yes. This is, in effect, we'll go back to the point of something which is void ab ovo, that is the controllet. We'll go back to the controllet because it is the controllet that lays the foundation for the judge to come to such a conclusion.
I see. It's all dependent on the controllet, you say.
It depends on the controllet. Then for me, then will be a bit, I will be putting, or my friend will be putting, sophist argument, my lord. I'm sorry. It will be attractive. It will be attractive,
All right.
but...
Could I just ask you about your notice, your grounds of appeal on page 307? And my understanding is you won on the first ground alone. And in fact, that was the one your side pursued on appeal.
Yeah, this is the only ground.
But if the judge had found, as has just been suggested to you, that in fact there was a mutual understanding in 1987 between the two of them, that he was to hold the property on trust for her, why does ground one of your grounds of appeal impugn that finding? If it merely says the contra letra was not lawful, rather than saying it was an inadmissible and the judge should never have referred to it.
Yes. No, my lord, we decided only on one ground because we believe that if it is not a controllet, then the 1987 deed becomes untainted. That's all.
Yeah, okay.
Yes, thank you. Proceed, please.
Thank you. Yes, I believe I have dealt with the grounds, the points that have been raised by my learned friend, but I would like to make two comments to conclude, my lord. The comments is in relation to the prayer of my learned friend. My learned friend is saying that two things. A is saying that 26% of the value in land. Let me read from paragraph 31 from his...
Which page?
Yes, the page is...
Was it the case?
If you want his case, yes. Yes. Try paragraph 30 of Monsieur Duval's case.
Thank you.
Yes. Then 31. First, my friend is asking that I'm appellant humbly praised that the order of the trial judge be restored. But he qualified the prayer. He asks for 26% compensation to respondent. My lord, even on this point, if we take for granted that 18,000 rupees out of the 68, if we go along the figures, that 50,000 for the price of land and 18,000 for the price of the taxes, then it comes to 26%. But there is the only evidence to that effect is that the land's price was 50,000 rupees, which means that even the 26% can be interpreted to mean more if we look at the 18,000 rupees in relation to the price of the land of 50,000, which is not 26%, then it comes to 36%.
Mr. Valéden,
Yes.
would it, even if we were to allow the appeal, and that's the hypothesis of what we're now talking about, would it be appropriate for us to give a direction to the master or registrar?
Your Lordship is right.
I'm sorry?
Your Lordship is right. I believe that it will not be proper to give a direction to the registrar, because I believe that the registrar will also have to go behind the veil in making the calculation and getting some facts about what is right and what is not correct. And these facts can be obtained from different authorities in Mauritius. And the second one, only as a matter of observation for the second one, is that the second property was bought while the couple was married communauté de biens. And as such, I humbly believe, that one can't say that respondents should be excluded from the 50-50% as per the motion law, as there is provision in law. If one wants the property to be on his own name, there should to go to a notary and inscription be made in a document. That's only observations, my lord.
I think, again, I think I understood what you were saying, although the line wasn't entirely clear. Were you saying that the communauté des biens principle would,
yes,
would or might affect the distribution of proceeds?
Would affect. This is
would
why,
affect.
Would
Thank
affect.
you. We'll make a note of that.
Yeah.
Mr. Verleden, is there anything else that you want to say in opposition to this appeal?
Only one issue is that on the issue of commencement de preuve par écrit, my lord, for me, again, to conclude on that issue, I have said it, I believe, several times, it will be an injustice, but it is a new case completely that will have to be decided if it is a commencement de preuve par écrit. And my lord, again, at one moment in time, Mr. Sauzier was referring to not any other issue, but that the money was only advanced to respondent. This I would like for the board to take into consideration. Page, which can be found, my lord, at page 80. Let me read that to conclude, my lord. Page 80 of the brief.
Page
80.
8 of what?
80. 80 of the brief.
80, I think.
80.
18?
88.
80.
80. Si.
Let's ask from 20. Your Lordship will see 3 lines from bottom, that is starting with my friend Gayan, SC. Well, I am sorry, just to get the record right, there is no question of lending money. It is purchasing. No advancing money. There is no mention of advancing. It's only to say that if it is a commencement de preuve, it will be an injustice to my client. Thank you, my lords.
Mr. Verleden, thank you very much indeed.
I have one question.
Lord Briggs has a question for you.
I asked Mr. Duval earlier whether I had misunderstood the essential nature of the phrase contre lettre by thinking it was essentially a document rather than a transaction. And he submitted that it was essentially a transaction and pointed us to some commentaries which suggested that you could have a contre lettre, i.e. a transaction, which was not in a document, i.e. one assumes purely oral or perhaps even by conduct. Do you agree with him, or do you have a different answer if I were to ask you the same question?
No, this is the jurisprudence française to which Mauritius has, I would say, incorporated in our law, and I agree with that submission. Yes, there's nothing.
Thank you.
Nothing. Thank you, my lord.
Any other questions? Any other questions? Mr. Verleden, thank you very much indeed.
I thank you, my lord.
Mr. Duval.
Yes, my lord. I would just like to answer on one aspect.
Speak up, please.
I'm sorry. I would just like to answer on one aspect, which is a great injustice being caused to the respondent because all of a sudden I introduced the concept of bac secret when the case was all about an acte secret. Now, to be clear, I agree that the contre-lettre was the kingpin of the case. It was at the center of the case, but not only as an acte secret, but as proof. And it is totally incorrect to say that the bac secret is introduced now. I invite your Lordship to look at the pleadings with me at page 6 of the bundle. Paragraph 9 of the plaintiff summons, I read, plaintiff avers that although she paid for more than half of the purchase price, the land was purchased in the defendant's name inasmuch as she was not, at the point in time, a Mauritian citizen, and the defendant herself had not yet contracted civil marriage. And the rest is what I'm referring to. But it was understood between the plaintiff and the defendant that the said plot of land was a bien propre of the plaintiff. Here is an averment of a bac secret from the very word go. Now, if we look at the next page, at paragraph 19, we will see why the contre-lettre was central to the case. Because it is a proof of an admission of the fact stated in paragraph 9. I quote paragraph 19. Plaintiff avers that on or about the 19th November 2001, the defendant signed a contre-lettre before the notary, Mr. Redmond Hart de Keating, in which the defendant admits. This was the whole time the case which the defendant, respondent, had to meet. That there was an understanding in 1987, that there was an admission in 2001. I therefore humbly submit that there is no injustice applying the law as it is to the facts as found approved by the trial judge.
Could you help me see whether I've misunderstood a passage that we were referred to earlier on page 80?
80?
80.
Yes. Yes.
Monsieur Sauzier, Maître Sauzier, saying, I think he's referring to what's entitled the contre-lettre.
Yes.
And he is saying it has to be produced first in order for your Lordship to see whether it is illegal or not. That's the question of, is it a valid contre-lettre?
In fact, the point was there that it was inadmissible, that the document was inadmissible because it was about an illegal transaction. And what Mr. Sauzier said was that on the face of the document, all it was that one person advanced money to the other.
But I'm just trying to see whether it was only being relied upon at the time. This is in front of the trial judge, this passage, isn't it? As a true contre-lettre. Or whether it was also being relied upon as evidence of its contents. And so we see, first of all, it's produced to see whether it's illegal or not. Even if it was illegal, the transaction was illegal, the document itself is not illegal, you would have to analyse the document in order to see what it says.
Yes.
So isn't that, on the one hand, it could be a contre-lettre, on the other hand, if it's not, it's evidence of its contents?
I think that's exactly what Mr. Sauzier approached the question. Because
so that was
Mr.
the
Sauzier,
case being run by Mr. Sauzier?
Yeah, Mr. Sauzier never, like me, considered that it could not be a contre-lettre because there was no evidence of simultaneity between the acte secret and the acte apparent. Mr. Sauzier said in his submission that there was simultaneity because there was the understanding since 1987. That is why, in my humble submission, there is a distinction to be made between the acte secret and the bac secret. There is, in my humble view, no simultaneity between the two acts. It's clear.
Because, as I understand it, you accept that as at 1987, neither of them thought that the 2001 document
would be necessary.
Produced.
Yeah.
Would be necessary.
God.
Yeah.
Is there anything else you want to add?
Not,
Mr.
my Lord,
Duval?
unless I can assist in any further.
There's nothing that we want to ask you further, Mr. Duval. Please sit down. The board wants to thank all the Mauritian lawyers involved and the London agents for the work they've done in this case. Even though Mr. Duval has been here in present before the board in London, and even though Mr. Verleden perhaps very sensibly exercised the option to make his advocacy by video link from Mauritius, there has been a very clear presentation on both sides. And I would like in particular to congratulate Mr. Verleden, being in Mauritius and having to project his arguments through the technology, for the clear way in which he has communicated to us. I am confident that the board understands all the points made on both sides, and it will now take time to consider its judgment.